Hello, everyone, and welcome to today's episode of Brief Encounters. My name is Maurice Bellan, and I am the managing partner of Baker McKenzie's DC office, but more relevant to this conversation, I lead our False Claims Act and government contracts practice. I'm speaking with Sam Buffone, who's the founding partner of Black Buffone, where he also focuses on the False Claims Act, investigations, and business fraud litigations. He's a former Senior Trial Counsel with DOJ's Civil Fraud Section, and we are going to discuss the False Claims Act, due diligence in M&A transactions. Now, to really jump right in, Sam, why don't we give our audience an overview of the False Claims Act before we jump into the content of M&A transactions and due diligence?
Thanks, Maurice, and really great to be here and be part of this. So the False Claims Act is the primary tool that the government uses to recover from fraud. One of the important things to remember is it's a civil statute, so it involves paying money, not jail time. As a civil statute, the burden of proof is preponderance of the evidence, so it's a coin flip +1. The knowledge standard includes reckless disregard and deliberate ignorance. And so because it's a civil statute, it allows the government to be a lot more aggressive, particularly when it comes to corporate defendants. So the elements of a False Claims Act violation is making or causing to be made a false record or statement or a false claim for payment to the government. The falsity needs to be material to the government's decision to pay, needs to be done knowingly, as I said, includes a lower knowledge standard. And some of the important things to remember with the False Claims Act is it includes treble damages, so 3 times the amount of the fraud, plus civil money penalties, which are indexed for inflation and are currently $12,000 to $25,000 per false claim. So it can have really large penalties. The numbers can get big quickly. It's also a whistleblower statute, which means that if someone believes a company or an individual is violating the False Claims Act, they can do what's file a qui tam lawsuit. So it's filed under seal in federal district court. It's only served on the government, so the defendant doesn't know about it. And the whistleblowers are incentivized to come forward. So if the government gets a recovery in the case, the whistleblower gets 15 to 25% of the recovery. And the whistleblower also can prosecute the case without the government. If the government decides it's a case they don't want to bring forward, the whistleblower can still bring the case forward and still litigate it on the government's behalf, and they get 25 to 30% of the recovery. So it's a really powerful tool the government has to root out fraud. It has potential huge liabilities for companies, and both in the investigation and the settlement can provide large liabilities and large headaches to companies. And with the whistleblower provision, it has a way of having violations come forward and having the government start these investigations.
Now, typically when we talk about the False Claims Act, most people associate it with the healthcare industry and government contracts industry. Can you chat a bit about the broader import of the False Claims Act and how it applies to a wider range of industries and not just the healthcare and government contracts industry?
Yeah, Maurice, I think that's exactly right. When you look at our economy today, the government plays a large part in so many sectors. And any way the government is paying out money, there can be potential False Claims Act liability. People who don't practice in this area often think it's only defense contractors. And as you said, one of the biggest parts of the False Claims Act is healthcare. Medicare and Medicaid is such a large part of healthcare today. And so any company that deals in the healthcare sector has potential exposure to the False Claims Act. But it touches so many other areas, and really any area that touches on government funds. So it can touch importation for customs duties. It can touch financial institutions that deal with insurance on government loans. It can touch insurance for lending for oil and gas royalties, telecommunications for government fees, educational institutions with student loans. Big tech you see moving more and more into the government space, particularly, you saw all the competition around the JEDI contract. And it seems to be an area that big tech is growing into more. It's also important to realize that this reaches companies that cause a false claim. So it doesn't just need to be the company that actually gets the money. It can affect downstream companies that are touching companies that are playing in the government space. So if a major customer of a company takes government funds and a company is helping that customer submit false claims, that company could be liable itself. DOJ recently issued a new cybersecurity initiative. This initiative is trying to go after companies that are dealing on government contracts or with government data or on government programs that aren't investing in their cybersecurity. The DOJ's view is that the only way to encourage good actors to invest in their cybersecurity is to punish bad actors who are not investing in cybersecurity. So we'll see how this plays out, but that really can play into a lot of different areas of businesses and a lot of different types of businesses, because it can touch any industry that touches the government in some way, shape, or form. It can touch anyone who deals with companies who touch the government in any way, shape, or form. It can touch cybersecurity providers and our cloud providers who are creating vulnerabilities, or any company that has a customer who is dealing with government information that are creating vulnerabilities for that company, that's creating vulnerabilities for the government data or government program data. So it really has a very wide reach and is much more broader than just your traditional prime contractor, your traditional healthcare. Maurice, I know you do a lot of work here. I mean, what are some of the areas that you see in enforcement that people don't think about every day?
Well, I tell you, what you just described is the reason for this podcast, right? M&A transactions cover a broad area of industries. And from an enforcement standpoint, I am seeing the DOJ be more aggressive with the False Claims Act in tying it to the certifications and regulations in a variety of industries. The False Claims Act has historically been used with FCPA violations. The False Claims Act is used in the EPA industry. I'm seeing the False Claims Act being used in some of our ESG discussions, certifications that companies are making to public companies about their ESG protocols. So whether you're talking about environmental, whether you're talking about infrastructure, whether you're talking about the financial industry, the False Claims Act is a powerful tool that the DOJ is using to leverage. And so when we talk about the topic today, due diligence and M&A transactions, transactional lawyers have to be on the lookout for a lot of different risk areas in the due diligence process. When they're assessing a company that is going to be acquired, they need to be looking for various areas that could create risk under the False Claims Act. And so what are some of those risk areas that our M&A transaction lawyers need to be looking for? One major area is in the area of compliance. Sam, why don't you share with some of our listeners some of the sort of compliance and quality control issues that typically come up that I think our M&A transactional lawyers should be thinking about when considering a deal?
Yeah, exactly. So, right, you're considering a deal now, you're doing due diligence, and when do you need to have this red flag going off in your mind that you need to be looking at False Claims Act exposure, right? Step one is going to be going through exactly what Maurice and I were talking about. Is this the type of company that has potential exposure? Are they in an industry? Do they have customers that touch government funds? And one thing I realized we forgot to talk about was the CARES Act, right? So many companies coming out of COVID have gotten some form of government support. So you need to look at the company and say, do they have potential exposure? Do they have the potential to touch the government? One great way to do this is to look at their customer list. Is the government a major customer? Are their customers people who deal with the government? And also look at the different offerings of the government that the company offers. Do they offer government insured or government backed or play in government program? Then you need to look at the company and say, is there some exposure here, right? The first thing is going to be looking at their compliance department. In looking at their compliance department, you need to be looking at what has the compliance department actually found? What do the QC quality control reports show? What are the compliance findings? What are the types of things that the compliance program is doing? And both looking at what they've actually found and ways that they might be glossing over problems that exist at the company. One of the ways I've seen the government, and when I was at the government, one of the ways that I always looked at compliance was not just do the compliance reports on their face show that this company is aware that they are violating government program rules and requirements, but is compliance being pressured by operations or others that they're finding in the first instance something is a problem and then changing their compliance reports to show that it's not a problem. Another thing you need to look at is the compliance robust enough, right? Does the company have a robust compliance program where it is able to suss out potential liability for the company, potential problems? If they're playing in the government space with this treble damages, with the civil money penalties, with the whistleblower provisions, you have a huge potential exposure for the company and for the purchaser. So you need to be thinking about, is the compliance robust enough? If it's not, is this a company that we want to invest in because we're going to need to build out that compliance function and make it more robust, because you need to have that robust compliance function to be able to play defense and make sure you don't have a problem down the line. You also want to look at the whistleblower process, the internal complaint process, and the escalation process within the company. Right? It's important to really remember that the False Claims Act is a whistleblower statute. Most of the best whistleblowers are insiders at the company. And insiders often blow the whistle, not because they're looking at that 15 to 20 to 30% reward down the line, but because they want to be heard. When I see whistleblowers, I see them as people who have tried to raise things internally in one way or another and felt like they've hit a roadblock, felt like they're not being listened to, and really just looking for a release valve. And so does the company have a process to provide their employees that release valve so that issues can be dealt with internally and they won't be turned into a whistleblower and won't be bringing a government investigation down on the company? I think it's also important to look at where the company's margins, particularly for government business, is coming from. You always want to be buying a profitable company, but if there are outsized margins with government business, you need to ask yourself why. Are they making more money off the government than the government would be expecting? And are they making more money off the government in a way that the government's going to look at poorly if they were to investigate the company? Is that a risk that your client wants to take on? And finally, I think it's important to look at business development in government sector. Right? The government takes a very aggressive and expansive view of a kickback, particularly in the healthcare context, but there's also an Anti-Kickback Act that applies to government contractors more generally. There are often things that would be acceptable in the business world, dinners, speaking engagements, things like that aren't allowed in the government sector. In the healthcare context, things that could be considered normal business development in other sectors are considered a kickback and potentially criminal, and also providing civil liability in the healthcare context. So you really need to take a broad look at the company, think about, is this the type of company that has potential exposure? What is the company finding out? And what are the parts of the business sectors that we need to do a little bit deeper dive into to see, is there risk here? And is this risk that we're willing to take on or risk that we don't want to take on?
Yeah. So Sam, you said a mouthful. And I think as you describe the potential risks and the potential issues that one needs to consider, as a private equity investor who is fairly aggressive in the M&A world and is looking at transactions, they certainly need to be worried about how their conduct can cause a false claim. So Sam, talk a little bit about how the conduct of private equity investors, can potentially cause them to be held responsible for a false claim. Because I think that's critically important to sensitize folks to the reach of the False Claims Act and how risk can be created through what you might think is a passive investment.
Exactly. It really is a broad statute, and it is meant to touch any type of fraud on the government, any player who is involved in it. So the False Claims Act doesn't just touch, as we talked about before, those who submit false claims, but those who cause the submission of false claims. And there is a growing effort and a growing body of law that holds that private equity investors can be liable for causing the false claim. So the company that's a private equity investor in a company that has potential False Claims Act liability isn't just putting their investment at risk. It's not just that the company they're investing in is going to lose value because that company is going to have to pay a large fine and pay a large judgment to the government. The private equity firm themselves may be putting the private equity firm and the private equity fund at risk, because it's been found that if an investor is involved enough in the company, they can cause a false claim. It really is fact specific. If you are truly a passive investor, you truly just make your investment and the company runs itself, then there should not be liability. But as we know, everyone likes to make sure that their investments are performing the way they expect. And so the more that a private equity investor is involved, the more that you can show that they have knowledge of the operations, that they are getting compliance reports, and the more that you can show that they have control of the company, that they are actively involved in the day-to-day management of the company and making some of the decisions, particularly when it potentially involves the core business of the company, and the core business of the company involves the government, there's potential exposure for the private equity company themselves. This is particularly true, I think, in companies that have core business dealing with the government, so a government contractor, a healthcare company. But you really need to think about, are you opening the investor themselves up to liability, right? And Maurice, I know you've had this conversation with due diligence. How do you talk to potential investors and potential companies about how they need to think about these types of problems?
Yeah. I think, when we are chatting with our deal counsel and clients about the False Claims Act and risk, it truly, truly begins at the beginning and the structure of the transaction. How a transaction is structured will determine issues or concerns of control, whether a transaction is going to be a JV, whether an entity is going to be a standalone entity, a wholly owned subsidiary, a joint partnership. All of these have considerations under the False Claims Act because, for example, are you going to set up a separate government contracting entity that is going to deal solely with the due diligence and compliance regime related to the federal acquisition regulations? Or are you going to integrate, that entity into the full operation of the company? There are different ways to structure entities and structure compliance that will be considered when it comes to what is the entity that is controlling compliance, causing a potential false claim, and creating potential compliance risk for the rest of the enterprise and the organization. So as you think through some of these issues, as you think through business structures, the company you're acquiring, the product that they deliver, the supply chain that is involved, whether it is a global supply chain, whether there's certain products that come from certain sanctioned countries around the world, you may have make certain business decision about the arrangements that are made on how you partner or engage with these companies going forward, again, based upon an analysis of False Claims Act risk and potential risk and exposure. So all of these things are things we like to talk to with our transactional counterparts and our clients on the front end, because it really helps inform them on how to structure and develop a transaction in a way that is going to minimize risk, but also inform the deal team on whether this is an investment that I think is worth making in the end. So if you do have questions, regarding how False Claims Act risk impacts your company, how it can impact a potential dealer's transaction, reach out to a specialist, reach out to Sam Buffone, reach out to myself and our team at Baker McKenzie, because we really can give you some helpful and creative insights on how to structure your due diligence, how to manage that due diligence in a way that is productive and proactive in order to complete the deal, but more importantly, assessing and evaluating the deal to see that it truly has the value that you intended or at least projected for the transaction.
Yeah, I think that's a really great point, right? It's important to get specialists involved early. They can help you spot if these issues exist because they're hard issues to spot. It would seem like it's easy on its face, but it really is such an expansive statute, and the government plays in so many different spaces right now that for those who don't deal with this day in and day out, it's sometimes hard to spot that there's even an issue there. And if it is an issue there, right, I think Maurice is exactly right that having a specialist who can help you think about the risks here allows you as the M&A specialist to figure out how you want to structure it to minimize those risks and deal with those risks. Right? When you're doing the due diligence, I think you also need to be careful. It can create a paper trail. It can create evidence that can come back to haunt the purchaser. Your paper trail should be privileged, but as we all know, everyone can get sloppy with privilege sometimes. And so if you have False Claims Act concerns, if you have a concern about a potential government investigation that might come down on the back end, you want to make sure that you are stressing to the client and stressing to everyone involved to be very careful with the privilege and be very careful to maintain the privilege. There's going to be deal documents and information sharing that is not going to be covered by privilege. And you need to make sure that you're not creating a paper trail there that can come back and haunt the company. I've seen government investigations where the government used some of the information that was passed back and forth during a purchase, during a deal, to show that the company and that the eventual purchaser was on notice that there was potential False Claims Act liability, and that was used to help establish the liability, have the company pay that large settlement down the line. And so you want to make sure that you are protecting your client at all stages of it and properly spotting the risk, properly addressing the risk, and properly dealing with what you're finding.
Yeah. And Sam, that is a nuanced and a process, because what you identified, the balance of due diligence, right? The balance of knowledge and knowledge that creates potential liability is something that is pretty delicate. I've had the challenge of some deal teams not wanting to dig too far for fear of what can be uncovered and then sort of hung on their backs later on with respect to a particular transaction. So I think the completeness of the due diligence, the depth of the due diligence is going to be proportionate to some of the risk factors that, during the process of a transaction and how far we take it in the measured investigation that needs to be done in order to ensure that the transaction is what it says it is and that the risks are manageable. At the end of the day, there's always going to be some risk. We recognize that we're going to proceed with transactions despite the risk, but it's about informing investors, informing our corporate teams about what those risks are and whether the value is proportionate to the risk factors that you're going to take on. One last question before we close out this podcast. If you're doing due diligence in a transaction and you find something that you perceive might be a risk, what do you do?
Yeah, that's a really tricky situation and one where you definitely want to get sophisticated defense counsel involved. But there really are two options, right? One, you walk away from the deal. It presents too much risk. It's not worth it to take that risk on, and you just walk away. Two, the company can self-disclose. DOJ has an official policy related to self-disclosures and voluntarily disclosures. The government's policy is that they will give credit for voluntary disclosure, and that takes into account the timeliness and the voluntariness of the assistance, the truthfulness, completeness, and reliability of any information or testimony provided, the nature and extent of the assistance, and the significance and usefulness of the cooperation of the government. But it's important to recognize that the government will always require the company to pay back at least the amount that it owed, and may require some form of multiplier on top of that. So know that if you're going to still go forward with the deal and make a voluntary disclosure, the company is at least paying back what it improperly took and maybe putting a multiplier between 1 and 2 with a voluntary disclosure there. But Maurice, how have you dealt with it if you've ever run into this situation?
Yeah, but practically speaking, Sam, if we run into an issue and now the company that we wished to marry and enter a deal with, we're saying to them in due diligence, I think we have concerns here that might need to be disclosed to the government. What are the practical implications of that? Does that potentially blow up the deal? Does the company that you're acquiring still want to go through with it? All those are questions that I think arise and issues that come up, but are risks that you've got to talk through with the deal team, or what the implications are, the domino effect of the deal and the multiple parts of the transaction. But again, it really gets to the overall value of the acquisition. And that's what we try to lead with in our conversations. If you uncover a risk that potentially will require disclosure and trigger a potential investigation, will disclosure mitigate that risk? If the analysis is yes, then yes, I think the timeliness and voluntariness of the disclosure, the truthfulness and completeness of the information you package and provide to the government could mitigate the risk for you. But again, this analysis is always juxtaposed against the value of the transaction and whether the deal is worth the long-term value. Essentially, at this stage, how we analyze risk and false claims is more integrated into whether the deal, again, purports to be what it was proposed to be. But I do think that that is a helpful final point to be raised with this community.
Yeah, and I think, great. The hope is that you're not finding anything and you're getting comfortable with the deal. But if you find something, it's going to be a problem you're going to have to deal with. And if there is potential False Claims Act liability, if you self-disclose, there's going to be an investigation. There's going to be a settlement. It's going to cost the company money. But if you don't self-disclose and there is an investigation and an eventual settlement, it'll be much more costly. And so that's just a calculus the company needs and the purchaser needs to make. So, Maurice, I really appreciate this conversation. I really appreciate the opportunity. This has been great and great to work with you. I think what you've done at Baker with going in on your M&A deals and talking with your transactional people and making sure that people are aware of these potential False Claims Act risks is really innovative and I think important and provides a great service to your clients.
Well, thank you, Sam. And it was equally as pleasurable to work with you. And this is, I think, a great benefit to the transactional community. And hopefully Sam and myself will be speaking with some of you about your particular facts and situations in the near future. Thanks so much.